Good morning, ladies and gentlemen. Thank you so much for attending this morning. We've got quite a wonderful turnout, and as it should be, because we've got quite a wonderful panel here for you this morning as well. So we're here for the new Companies Law, which was announced in October 2025, where amendments were issued to Federal Decree Law number 32 of 2021 on Commercial Companies Law under the Federal Decree Law number 20 of 2025. Now, as you know, these changes became effective from the 1st of January 2026, and they are designed to simplify how companies operate onshore, and they're also designed to increase corporate flexibility and embed governance tools. So this is a major step taken by the UAE to modernise the current corporate legal framework. And in this session, we unpack the new law, and who best to deal with that than those leading the charge. And so bringing the topic to life this morning, and it's a real privilege to introduce all my panel members, but starting with Hassan Al-Kalani. You will know Hassan Al-Kalani, he needs no introduction, but just so that you all know, and just to sort of remind ourselves about the leader of the charge, as I say, he is one of the most influential general counsels in the UAE. He's a leading figure in the modernization of commercial and regulatory law in the region. Hassan has been instrumental in shaping and implementing transformative legal programs across the UAE and wider GCC, aligning federal legislation with evolving business models and global market realities. He has authored and led key reforms in areas including commercial agency, commercial registries, arbitration, intellectual property, and digital trade. And most recently, he's played a very central role in leading the charge with the new law. Hassan also spearheaded the creation of integrated economic data ecosystem from commercial registries, setting new standards for regulatory agility and transparency. Beyond the region, his work has had a global impact, most notably through proposing the UAE's trading by modern technological means law to UNCITRAL as a model for international digital trade, a topic very close to my heart, and I might speak to you later about that. And so this is Hassan, and he brings an exceptional combination of technical depth as well as understanding what the law that we're discussing here today is all about, and he'll talk us through that. So that's Hassan. Right at the end is Amira Fayyad. Amira is an Associate Director for Legal and Company Secretariat at Siddiqui, where she sits firmly on the in-house side of the table, advising on governance, data privacy, regulatory compliance, and commercial risk across the group. She's a legal professional with over 10 years' experience and a certified family business advisor. And we'll hear from Amira in terms of the operational perspective, how regulatory and legal frameworks will be actually implemented inside organizations and where the friction points may arise in practice. And therefore, there's a valuable in-house lens to today's conversation brought by Amira. Last but not least is Sama, again, who needs no introduction. Sama is a partner at Al-Tamimi. He served as the firm's managing partner from 2020 until January 2024, during which time he led the strategic and operational direction of the firm across Middle East and North Africa. Sama heads up the corporate department at Al-Tamimi's, overseeing a region-wide team, advising on complex structuring and restructuring and transactional work across the GCC. With over 2 decades of experience, he advises blue-chip corporates, financial institutions, government and semi-government entities, private equity funds, and high-growth businesses in MA joint ventures. In parallel, and this is where it's a very nice complement in terms of Amira and Hassan, Sama has played a significant role in legislative development, contribution to the enactment of local and federal laws, and leading reforms in free zone and special economic zone frameworks across the GCC. His background as a litigator also gives him a deep and practical understanding of how corporate law operates, and especially when things go wrong. So in terms of the fourth panelist, there was Havith listed on the programme. Unfortunately, he's unable to join us today due to medical commitments. but we were very grateful in putting this session together for his input, and we welcome him to a future session. So without further ado, now that the introductions are done and now that you know how esteemed our panel members are, I'd like to start with Hassan and obviously with the policy objectives and the UAE's positioning, because over the last years, we've seen not incremental change, but what I would describe as a deliberate recalibration of corporate law and the framework of corporate law. And when you sent me very helpfully what the new law was about, what one can see is that these reforms aren't cosmetic, and they go to how UAE competes and attracts capital and structures enterprise in a global market, which was something that led to a very fruitful discussion whilst we were talking about the panel. So Hassan, if I can go to you, you have been at the centre of this process, not as a commentator, but as the author and project lead. And as the senior legal advisor to the Ministry of Economy and Tourism, you led the drafting of this new law, building on what you said, decades of evolution when we discussed it. And so can you please walk us through the story behind the amendments, the methodology, the drivers, the considerations, and how do these amendments fit within the longer legislative evolution of the UAE Companies Law when you look at it from over the past, let's say, 4 decades, nearly 40 years? And what do you say makes this phase of reform distinct from those that came before it?
Thank you so much.
I might give you that.
Yeah.
Yes.
Morning, everyone. Let me take a step back. Companies in UAE, they're subject to different legislation depending on the geographical jurisdiction. It could be onshore, as you're pretty aware, one of the 7 Emirates. Then it could be in one of the free zones, which is more or less linking the dots with the onshore. However, the interesting part is the free financial zones, ADGM and the IFC. The Companies Law started all the way back in 1984. This is the journey from the first time where UAE decided to come up with a Companies Law. Back at that time, it was compatible with the, I would say, the assumptions plus the strategic evolution of UAE. The second wave of this law came in 2015. I still remember when I first arrived to UAE back in 2005. 2006, we read the final draft of the Companies Law. It extended from 2006 to 2005 up till 2015. Almost 10 years to come up with the new law. That was for different reasons, for sure, not to mention the stakeholders around the table. Stakeholders, simply local Emirates, the IFC, ADGM, free zones, not to mention the investors' appetite. 2020, there was a dramatic, I would say, scale up to the law, whereby more or less there were no barriers towards foreign investment. Yet again, we came up with the 2021 law. Good enough, very different than the preceding journeys of the Companies Law. Yet again, you need to test the law. We came across several instances whereby we seriously witnessed legislation gaps. Then it was left to the licensing authorities to come up with innovative solutions. One of which, the transformation from the form of LLC to private or public joint stock company. In the typical case scenario, this is one-to-one, I would say, assumptions under the Companies Law. The autonomous entity will still exist during the transformation. So you will not come up with a newborn company. It will still be the same company. However, the form will be different from LLC to private or public joint stock company, correct? The challenge simply was during the transformation of one of the huge LLCs in UAE. Okay, we want to transform it. Brilliant. The best fit is private joint stock. Why? Governance. So there's no board of directors in LLC. Hypothetically speaking, we define the group of directors as board of directors, but in fact, they're different from governance perspective. Once the transformation is done, where's the board of directors? There is absence for the board of directors. The registry element is not there as well. Another incident was simply in Abu Dhabi. 3 major co-ops merged together and they transformed into a public joint stock company. So ESCA back at that time, the old name, the current name is the...
CMA. The CMA, the Capital Markets.
Thank you. Rasha, by the way, is from DFM. She's one of the stakeholders actually participating in our journey for this law. Thank you, Rasha. So there was basically this reluctance with ESCA how to treat this new form. It's not a company, it's a co-op. In the co-ops law, we had an explicit article simply saying co-ops can transform to any form of a commercial company. However, there was no mirroring article in the company's law. Fair enough? We started the journey. Okay. I've been with the Ministry of Economy for the past 4 years as an in-house. Before that, I was in Simmons & Simmons, and the ministry was one of my clients. Long story short, the ministry decided to come up with upscaling the commercial laws. So now we operate literally, and our colleague here, Sufyan, he comes from the private practice as well. We operate in the Ministry of Economy literally as a private sector. Quote me if I'm wrong, okay? We simply operate, we simply think, we simply come up with objectives, targets, aggressive, I would say, up and beyond the objectives or the deadlines of the private sector. The pressure is definitely holistic. When we've started first our journey with the amendments, around the table, give and take, 50 participants, 50. I still remember, and I will not actually forget. Introduction, etc., and so forth. And I told them, well, hopefully within the coming, when I say hopefully, it is happening. Hopefully within the coming couple of months, we will be done with the law and it will be enacted. Among all the audience, with no exception, they all burst into laughter. Companies law will come up in 2 months? Okay. Yes, it will. The whole methodology was different than the preceding methodology. How? I believe you already witnessed that. We were co-authoring the updates with the relevant stakeholders. I'll walk you through different, by the way, updates in the law, whereby these updates were proposed by stakeholders, not from the ministry. It was not even on our list. One of which was the relocation of the commercial registry. That came to us as a demand by ADGM, DIFC, and even the licensing authorities, the EDs. Drag-along and tag-along was one of them. Then the whole thing started, the journey was the multiple shares, with pride I say, multiple shares in the form of LLCs. With pride I say, UAE is the first country in the Middle East enacting multiple shares for LLCs. The commonly followed trend is the public listed joint stock companies, very acquainted with the multiple stocks. In the olden time, it was even the methodology to introduce the multiple shares was as an exemption. When we say this in the legislation theory, so the exemption, it's not a right, it's not an entitlement. You have to justify why do you want to have the exemption, and it will be, the interpretation will be limited to the narrow end. We flip the coin, we flip the table, and nowadays the introduction to the multiple shares will be as an entitlement by definition. It will not be treated as an exemption. Long story short, I don't want basically to burn the other points. Apologies for that. I think it was a smooth journey, 2 months. When the stakeholders feel that the law comes to treat legislation gap, the law comes to help the stakeholders to make ends meet, not to challenge them. This is how and when we came up with the right assumptions, the right outcomes in a super short deadline. Thank you so much.
Thank you for that very comprehensive answer. And we'll turn to Samer shortly about whether or not it does fill the gaps. But I've got a couple of questions arising from what you've said. One of them is that you've spoken about how the law allows a transformation process from LLCs to PJSCs, public joint stock companies. I mean, do you see this as the most structurally significant aspect of the law that's going to affect the UAE corporate system? And if so, why? And if not, what are the others?
Definitely. And we're expecting the churners, I would say, the migration from to onshore, offshore, family companies, mainly. I think they will have more incentives to knock the doors of the free financial zones due to the succession plan, the contractual side of the arrangements, rather than staying onshore, encountering the turbulences as from investment perspective, not from Sharia perspective for sure. They would have limitations towards the Sharia compliance, inheritance, succession plan. The methodology of the company's law, it comes in line with the past 4 years methodology, coming up with a new theme to drafting legislation. What is it? You will start hearing this a lot, agility. Agility in legislation, seriously. 101, when you go to the legal stream, the faculty of law, they will tell you, law is rigid. No, it's not rigid. It's stable. It is stable, it is not rigid. And I can demonstrate basically otherwise. Agility in legislation, what does this mean? So if you notice, several laws starting from the commercial registry law, the commercial agency law, the co-ops law, the trading by modern technological means, which takes over the e-commerce and digital trade. And this is one of the laws that I took it all the way up at international level to consider UAE as a benchmark for UNICETRAL to come up with a model law. So there is no digital trade model law. UAE has achieved the first precedent worldwide. It is tangible. December, in a couple of months, we had a holistic event for 2 days. UNICETRAL was there, WTO, UNCTAD, etc. and so forth. It was adopted, the proposal was adopted, and now we are translating or attending to these objectives. What does agility mean in legislation? Simply put, number one, the law will be used as an enabling tool and not as a bottleneck. In the typical case scenario from legal perspective, no can do. The law does not provide us to do that. Okay. Or the law specifies specific number, specific percentage. Correct? This is all what we face on daily basis from legal challenges. So we thought, okay, let's come up with a more resilient legislation, more adaptive legislation. So we'll come up with an overarching law, and we will leave the execution to the law by respective regulatory instrument, cabinet resolution, ministerial resolution, which in the typical case scenario will be pretty easy to update and amend. Once and when required, it will be very much easier to adapt to. Unlike the law, you have to exhaust the whole legislation cycle. And lucky you, if you go to the Federal Council with the multiple committees, then go public, you need to convince actually the stakeholders or the decision makers with your narrative. So agility, I would say, is the proper address to make the commercial laws adaptable, up to speed, and enabling investment to take place in UAE in the proper context. We don't challenge nowadays. We don't challenge business getting in UAE. On the contrary, we sit with the investors. We co-author hand in hand, and I mean it. We co-author laws, legislation with stakeholders. The family business law, for example, was co-authored by one of the general counsels in the family companies. It was co-authored by him, then introduced to the Ministry of Economy. To that extreme, you will find nowadays the perception, the methodology of coming up with laws in UAE, mainly in the commercial stream. And this is how you will see the holistic upscale and the commercial laws. Thank you.
Wonderful, thank you. And I like that, the agility in the law, it's sort of symmetrical to what UAE, I suppose, stands for. But let's now test that proposition. How agile is it? Samar, I'm going to turn to you. So from a market perspective and an advisory perspective, what would you say about the agility of this law? So putting it differently, how is it being received and recalibrated in practice? And are you seeing clients changing or wanting to change their behavior as a result? So test the proposition, agility, yes or no?
Thank you. Well, first of all, let me agree that this is probably the most structurally significant reform in the corporate landscape in the UAE. So I would definally agree.
Agreed.
With
We agree
Hassan,
with
I would
that.
give
We
you
agree
this.
with that.
I would give you this, but we're not there yet. So to your point, of course, I mean, maybe I should give a bit of historical background as well to Hassan's point. I've been practicing here for over 26 years. So I've seen it all. Yeah, I joined at the age of 10. And I've seen the challenges. And my practice is very much around attracting foreign investment to the country. So I'm a salesman, basically. And I rely on the tools that are available for businesses to structure in the country. And my main objective is to find a structure that would work for different stakeholders. So onshore in particular was actually extremely challenging. From day one, we came to the UAE when the Commercial Companies Law had statutory restrictions on ownership. So that by far had pushed all businesses to structure in free zones. And when we looked at the free zone companies regulations back then, they were also falling short of many of the concepts that are required by investors, by founders, by family businesses, and what have you. So we had to work on reviewing those companies' commercial law. And guess what? We've introduced different classes of shares in free zones as well.
Yeah.
But then we faced other challenges that are missing in other free zone tag along, redom, and what have you. We had to introduce them as we go. We've done that in the free zones. Then the IFC ADGM came online. Again, because of the restrictions onshore, it had pushed many businesses to go to the free zones. And again, posed extreme limitations on structuring in the mainland. Now, the reason why I said this is actually significant because now you have a full menu. You have the option to structure onshore, and you have the option to consolidate your business. And not only that, you can actually restart because my team and I are busy in restructuring businesses. Every now and then, there is a piece of legislation that comes online which triggers a need to revisit your structure, tax laws, Emiratization, and what have you. But it was a reactive approach in all these instances. Here, we're talking about a more proactive. There are benefits of doing so. So I guess now is the time to pause and revisit your structure and look at how you can benefit from those amendments. Now, to the point about agility, of course, the way that it was designed, yes, it is very agile. But now all boils down on what comes next. And these are the decisions, the cabinet decisions and the implementing regulations that we're hoping will be very much in line with at least the hopes of businesses. Because speaking of experience, and I don't want to basically jump to conclusions here. Speaking of my experience in free zones, the main challenge that we often face is the implementation phase. When you go and try to implement those different classes of shares clauses and what have you, you're basically faced with the reality that the implementation is different. And you need to educate the team on the front desk that things are done or should be done differently now. And this is what is actually yet to be seen.
Thank you for that, Samer. And 2 points arising. I can agree with the implementation point because I recall in the free zones with the bankruptcy type legislation, it was very difficult, for instance, to go and send bailiffs because these are concepts that aren't necessarily understood from a civil law perspective. And it brings me on to another point, actually, because let's take, for example, classes of shares. That's not, as I understand, and I'm a common law practitioner, that's not necessarily a civil law type domain. And what seems to be happening here with the new law is that there are aspects of sort of common law that's being adopted. So, for instance, classes of shares. Now, again, coming back to your point on implementation and education, Hassan, I'm going to ask you, has there been any thought around sort of cascading education around the law to those people that are actually on the ground implementing?
Excellent. Thank you so much. There will be 12 resolutions executing the amendments of the Companies Law. 5 cabinet resolutions, 3 ministerial, then the others by ESCA, and 1 by the local authorities. Mainly, the heart and soul of these resolutions again stem from the fact of agility. So if and when there is any need to update these resolutions, it will be updated. The same methodology followed in updating the Companies Law will definitely be applied to the executive resolutions. It will be co-authored by stakeholders. You've mentioned orientation. Last year, we came up with a more challenging, by the way, target. So we said, we're in the typical case scenario, we do plenty of orientation sessions. Let's come up with a more crazy idea. How about we start marketing our laws? What? Market what? You're going to market your laws? Yes. That was basically a debate between me and the minister and the undersecretary. How would you do that? Can I pick on the commercial
Yes, of course.
agency law? So the commercial agency law, the new one,
Yeah.
comes after a preceding law which existed over 42, 43 years, more or less. Definitely associated with the Orthodox marriage. Okay. And I would say the qualification for the local agent was only associated with the UAE national, whether as a juridical person or natural person. Is this still the case? And I'm bridging to the point of the marketing side of the legislation. Not necessarily, because we open two windows for non-locals to be qualified as commercial agents. The first one, 100% non-local. How could this happen? If the agency is brand new to UAE, so that does not and did not have any commercial agent before. Number two, if this agency itself is one of the subsidiaries of the parent company, this parent company establishes a local presence onshore in UAE, and it will sign a commercial agency agreement with the parent company to sell the products of the parent company. The counter argument, we have this counter argument, by the way, in the National Council, so I'm sharing with you. It's not confidential anymore. So we have this counter argument with the National Council. But they can have the direct access to the market. Definitely they could. But guess what? They will not entertain exclusivity. If you are a commercial agent, qualified, you will definitely entertain exclusivity. Now, coming to the marketing part, approaching the international investors, approaching someone like Amira. Amira, guess what? You have this particular agency. I think it's mature enough. You're done with it. The market value, more or less, is getting into the saturation level. How about we, as the Minister of Economy, help you to scratch your head and come up with a holistic investment opportunity? How could this happen? Flip it into a listed company, public joint stock company. You will still own 51%. 49% will be floated in the market. And nowadays, imagine we are marketing, we are acting as sales.
Yeah.
We're acting as sales. And we are marketing for our laws. Nowadays, by the way, on the way actually to the event, I was discussing with Samer. How about, and please, I urge you as well, approach me if you need it. If by any chance you need any orientation within your organization, your company, please approach me, approach Samer. We're more than happy to do one-to-one sessions with you. One-to-one session with you. Okay? Free of charge. I will not charge
I
you.
wanted to ask, is it free of charge?
Yeah, it is free of charge.
Families.
We're on camera. Of course.
all of these witnesses.
Documented.
Yes.
So we're beyond nowadays sitting back in the office and drafting legislation. Then guess what? Shocking the investors. This is gone and dusted. It does not happen anymore. And definitely it proves failure. What we're doing nowadays, we're not doing public consultation. Yes, we're doing public consultation, but we're doing beyond public co-authoring. We're to that extreme, transparent and beyond. So if and when you have anything which makes the law, the legislation cycle, more encouraging, more like doing business in UAE, please make it happening, introduce it, and we'll take it from there. We came up with 15 updates in the law and one fresh new article. So we've amended 15 articles and we came up with only one new article, technically speaking. Our dream definitely was more than that. We had to compromise on a couple of articles just to make sure that this project, let me call it project, it is project by definition, this project will come at 100% consensus position by every respective stakeholder. For those who don't know the legislation cycle, now by the way, all of you, you read the final product. You know you don't know what's happening back in the kitchen. You cannot imagine the exhaustive political on one hand, legal on the other hand, strategic on the third aspect, challenges with every respective article. You cannot, and to make ends meet, every local entity has its own conflicting position. Another example, I believe most of you, you're acquainted with the updates to the arbitration law. One of the local entities, they proposed that, well, we have this challenge towards appointing one of the arbitrators from the executive or from the board of trustees. We listen. We are the regulator, we listen. We populated the idea with every single arbitration center in UAE. All of them, they said no. This is not in line with the proper governance. So now I have to make ends meet. We came up with a mid solution. We say, yes, it's not doable. However, we can do it subject to the following corporate governance standards. Guess what? It's 101 governance standards. Nowadays, this is the way how we operate towards coming up with the legislation. Now you see the final deliverable, the final product. Give us some sort of feedback for sure, and definitely approaches. Thank you so much.
And this is again another limb of agility, I'd say, because you won't find many jurisdictions where the person who's drafted the legislation will actually give you a personal invitation to come and have a one-on-one. So another limb to the agility proposition. But now that we've heard from Samer and Hassan about the sort of structure, we'd like to sort of turn to Amira to bring the in-house view. And so, Amira, from an in-house perspective, the added flexibility and the agility that we've heard about, does that make governance and shareholder management easier in practice as far as you're concerned? Or in your opinion, do you think it's going to introduce layers of complexity at board and shareholder level? And just to sort of follow on, are you hearing any concerns from the boards and their shareholders and about the structures proposed?
Thank you very much, Bushra, for the question. To be honest, we haven't been in discussions internally at Sodiki about these changes because they are very recent. But of course, we'll be discussing them very soon. But I'll tell you from my experience and from what I'm hearing as an in-house counsel, I believe based on what Hassan and Samer said, it's very clear that these changes, and particularly the multiple chairs classifications, has offered some flexibility to companies, particularly in terms of financing and governance. Of course, this will depend on the cabinet resolution that will be issued. So Hassan, we're waiting for this from you. It definitely will simplify governance and shareholders management because companies can now clearly differentiate between financial participation in the business and control, which is a very commercial need by businesses. Samir earlier today, he was talking about how investors weren't comfortable before to set up entities onshore, which is unlike family businesses, right? Because we know, all of us, we know that family businesses, they're very keen to be in LLC. They're more comfortable to have LLC in mainland. So this will definitely help them in having such rights in the memorandum of associations, which will increase transparency and enforceability of such rights. And because now such rights can be included in the constitution document and the memorandum of association, they become more enforceable. And now the conversation with the shareholders and the board will be much easier. Because in the past, onshore companies who used to be interested in having such rights, they used to include them in shareholders agreement or side agreements, right? And the conversation about enforceability was very difficult with the shareholders. There is no GC who would like or who would enjoy explaining to the shareholders that, hey, this is signed, but at the same time, there is a risk of enforceability, right? But at the same time, so we have this flexibility. We said it increases or simplify governance and management of shareholders. But at the same time, there is increased risk of shareholders misunderstanding, especially, for example, when it comes to the multiple shareholders classes, right? Because you will have shareholders who doesn't really understand whether their right is really related to control or it's more of a financial related right. And here I see the job of the General Counsel and supported by experts like Hassan and Samir to explain to the shareholders and educate them, right? So we spoke earlier today with Hassan and Samir educating the people who are at the authorities or also educating or sending the message to the authorities to make sure that we have laws and regulations that really reflect what the business and the investors need. So here we're talking about educating the shareholders. And another job that is very important for GCs here is to really look at when they're drafting these rights, make sure they are coherent, they are consistent, and they are aligned with other statutory provisions under the law. And at the same time, they are aligned all through the MOA and other shareholders agreement or family protocols. And of course, once the cabinet resolution is issued, we need to make sure that they are such rights are aligned with such resolution. So in summary, these tools are very important, but I don't think companies should just go and take quick action and try to implement everything there. They should have internal conversation and based on the shareholder strategy, the company's strategic objective, implement what would work for them, educate their shareholders, make sure they understand what changes are being done, and make sure they really design them in a proper way.
Thank you, Amira. Now, just to sort of take it out of the abstract and bring it back to the region, I think I read somewhere in terms of a statistic that that private companies, family-owned businesses, so to speak, make up about 65% of the companies within the region. And so looking at the new law, thinking about what all of you have said, how do you see, and particularly the sort of share classes, how do you see this new share class framework being used in practice to support family business structures? And then if I can just add a bit more nuance to the question, we've seen kind of over the years how the family businesses descend into disputes, for instance, and I say that as a dispute litigator, so trying to bring my angle into it. How do you think the flexibility provided by the new law will resolve, let's say, long-standing family tensions? And do you see, for instance, this kind of share class introduction helping that? So I'm going to Amira.
Sure.
Yeah.
Yeah. So talking specifically about family businesses, I think the multiple share classes is really like a brilliant point added by the regulator. There has been historically governance tension between control, decision making, and financial participation into the business when it comes to really to family businesses. And how this tool will help, because now you can have shareholder or family members who would have rights, economical rights, right? And other shareholders or family members who would have control rights, and mainly the founders or the main family members who are in charge of the family business.
Yeah. I mean, I can agree more on what Amira said, but I'd like actually to emphasize a couple of points here, which you said earlier, Amira, and they're crucial for for actually all stakeholders, not only family businesses, to bear the fruits of that amendment. So, yes, now you have a statutory right, to your point, Hassan. It's an entitlement. It's not actually anymore an exception. But there are two streams that we need to really ensure that we're doing right. One is the implementing regulations and the cabinet decision. That should actually very much emphasize that point, that it's a right. So it gives agility, flexibility for all stakeholders to design it in the way they deem fit. But then the challenge is you have this right and statutory right, and you have the ability to have different classes of shares. You need to be very careful how you draft it. So there is no ambiguity around drafting, because if that is the case, then you're faced with challenges of enforceability, and it defeats the whole purpose. For courts to understand, for shareholders to understand, for every stakeholder to understand the different classes of shares that you're introducing into your constitutional documents, yes, one, you would need to go back and revisit everything that you've drafted earlier, shareholders resolution, all these side agreements that were put in place to go around the statutory restrictions, your policies and what have you, the different or conflicting interests between the business. Take all that on board, minority shareholders, take all that on board and draft your documents carefully, so no one can actually have different interpretations of the intention of the parties when they drafted it. And you can maximize your chances to get those documents enforced when you go to court.
Again, I've mentioned there will be 12 resolutions executing the amendments of the companies law. We already populated, shared with stakeholders, draft resolutions. The first two related to multiple shares, one for LLC, the other one is for private joint stock company. Then eliminating the taboo area for transforming ownership in the private joint stock companies. The following one will be related to, and this is actually dear to my heart, the commercial non-profit companies. We've managed to strike an arrangement with the cabinet. 6-8 months ago, the cabinet came up with a draft law for commercial non-profit companies. And we were trying to convince the cabinet that we can still do that in the companies law.
Which I must say had faced significant challenges in implementation.
Correct. Yeah. What we have done, if you read, by the way, the updates to the companies law, and by the way, to make everyone's life easy, it's available on the ministry website, the updates, bilingual in Arabic and English. Summary note, just go to the website of the Ministry of Economy and Tourism. You will see, and my LinkedIn account, you will see it as well there. It is basically introducing the journey of the company's law, then these amendments. What have we done with the commercial non-profit companies? Agility again. How do we translate agility in this article? Imagine we've managed to come up with a whole law by definition in one article, stating the platform of commercial non-profit companies, leaving the execution to a cabinet resolution. The whole law was abstracted in one article in the company's law. Most of you are definitely interacting with the amendments to the company's law. If by any chance you are subject or keen as well with the multiple shares, either an LLC or a private joint stock, in addition to the in-kind, by the way, assessment, this is another dilemma. Listing for private joint stock company, please introduce yourself. Nowadays, in this concurrent actually phase, we are populating the draft
enjoying
with
I know.
stakeholders. Please
on a roll.
introduce yourself. This is basically an advantage to this event.
Yes.
Okay, so please introduce yourself and we will share with you the high-level assumptions in these drafts. And definitely, we want, as Samer just mentioned, we want these implementing regulations to be as successful possible to make your life easy at the end of the day. It is not meant to be whatsoever as a bottleneck. On the contrary, the whole objective to
Don't make
the
it very
amendments-
easy, otherwise you'll put us out of business.
Definitely.
We need to be able to advise.
I'm not worried about you. You will work both ways. I'm not worried about
But there's
you.
always a dispute.
Yeah, of course, of course. So please approach me, introduce yourself if you are interested to get into the journey of drafting or being part of the team to drafting the execution resolutions. I know Samer is and Amira is as well. Thank you so much.
Perfect. Just to, so you've heard, you've got personal invitation here. Let's create new jurisprudence, shall we, just in this room? But we're coming to the end of the session and we are going to have question and answers. But I just want to summarize some of the points that we've all heard today. In terms of the key amendments and their roles, number one, allowing multiple classes of shares and equity interests, allowing transfer of company registration, which Hassan touched upon as well, regulating relations between partners and shareholders, including drag-along and tag-along rights. Whilst we've touched on that, the latter part of that amendment, I was going to ask about that, but I'm afraid we're running out of time. So, of course, you can come and ask questions about that. The fourth real key amendment is changing the approach to lock-up periods for private joint stock companies. That's not something that we touched upon, but again, feel free to ask a question. The fifth amendment was the harmonisation between local legislation and free zone laws. We heard about that, how there's a sort of a merger, if you like, of those two aspects. Number six, introducing standards for valuing in-kind contributions. And again, that's something that we didn't touch upon, but it's there in the law. And then we've got number seven, legal transformation of companies, which we touched upon very slightly. 8, another key amendment, establishing branches and representative offices of free zone companies in the UAE, touched upon that briefly. Number 9, strengthening the granting of UAE nationality to companies, touched upon that. And 10, introducing the non-profit commercial company, didn't touch upon that. 11, regulating the disposition of shares of deceased partners or shareholders. Unfortunately, we didn't touch upon that either. But those are the key amendments, some of which we've spoken about today, some of which you can answer in the Q&A session coming up. But very, very quickly, I've got a couple of minutes to round off. Turning to each of my panel members, thank you so much, first of all, for your very illuminating contributions to this discussion. I think it could have gone on for at least another couple of hours, especially with Hassan, the advocate for it. But just if I can turn to each panel member, Amira, starting with you, if you had to take one key takeaway from all of the new amendments and what we've discussed this morning, what would that be, particularly in terms of pragmatic sort of next steps and what to do?
Go back to your company's documents, review your memorandum of association, your shareholders' agreement, your family protocol, and your internal processes for decision making, and make sure they all say the same story.
Samer?
Yeah, well, I would endorse this. Again, I wouldn't look at what is the best. I take a holistic view, and we advise businesses generally to revisit their structures. This is how we sell it, basically. Speaking of marketing, we reorganize companies depending on the opportunity that comes online, and these amendments are an opportunity. So to Amira's point, I think, yes, companies may not have had the chance to discuss these amendments yet, but I guess this is a big item on board's agenda and on legal counsel's agenda this year, is to revisit their structure, look at what they can benefit from that, from those amendments, be it on different classes of shares, be it on redomiciling their entities from one free zone to the other, from a free zone to onshore. Look at the tax implications as well of that. Look at basically their financing documents, how they can benefit from that, how they can segregate the control from the economics. There are lots of work to be done there, and I believe this is a big item for companies to discuss.
Apologies. Sorry,
I want to say one more thing. I think it's also an opportunity to rethink governance intentionally. So many companies in the UAE have been operating based on governance rules because they are mentioned in a very old MOA or because they are required by the law. But now with all of these new tools, it is an opportunity to rethink about governance and make sure that it works for us today. Thank you. Sadi Hassan.
We're good? Okay.
you take away.
For the very first time, I kept actually this for the last point. During the lifespan of the company's law, we are reading explicitly the reference to free financial zones. And we gave the free financial zones two incentives. The first one, companies incorporated, not a branch. Companies, me and Samer, we go to the IFC. Me and Amira, we go to ADGM. We incorporate a company there. Okay? This company will hold the UAE nationality, not the shareholders, the company. Okay? And that was one of the incentives to free financial zones. Every single company incorporated in free financial zone will earn by law the nationality of UAE. Number two, if and when onboarding, offboarding to the IFC, ADGM, free zones from one emirate to the other. In the typical case scenario, let's park aside the onshore element, offshore. It was treated as a newborn, correct? You had to wind up and establish a fresh new company, entity. This is not the case anymore. There will be the continuity of the autonomous entity with all the rights and duties. This will be associated definitely with one of the, actually it has 3 different execution regulations. 3 different. One will be cabinet, one will be between emirates, then one will be ministerial in charge of the private joint stock company. This is just to, that was your earlier question, to identify the vehicles incorporated in UAE at a unity. They can onboard, offboard with a continuity of their life cycle. They don't need to shut down and reopen again. Thank you again for your time. All these and beyond, you will find it as well in the summary note in the Ministry of Economy.
But they're not clear. Come to us for a question.
Samer is indispensably needed for sure.
And given we're all sort of openly saying we're salesmen, all the GCs in the room, do find a good lawyer. With that, can I just say, before I do open the floor for questions, I just want to say a really big thank you to all the panelists. I thought they were excellent, they were illuminating. I thought it was a very engaging discussion. So thank you for spending the time with us this morning. And thank you to all of you as well for taking the time out to join us, for being present, particularly with the traffic situation. So very grateful to all of you. Now I'll open up the floor for questions.
Thank you. Actually, the question already, thank you, Hassan, for answering on that. My question was regarding the register. The intention of that since you are moving from register to another one, you know that the name might be duplicated. So once you have one register, you will avoid this duplication. The other thing, that you have the register number for each property, from else to another else. Once you have the federal registration, so you have a federal number for the registration. So this will be a unique number for each company.
You're absolutely right.
Which one will not
Okay.
change?
That was my first project actually in the Ministry of Economy. Literally, that was the first law that I have basically authored, the commercial registry law. The commercial registry law operates onshore, offshore, except for the commercial, the free financial zones. So every single free zone authority is subject to the commercial registry law. It was exactly as you have introduced, Fadi. So what to do if in case of having similar names? Not to mention another requirements that we are urgently, by the way, exposed to, one of which is the KYCs. Okay? Different opinions, again, with the charming cycle of the legislation. So we came up with a new theory under the commercial registry law. In the typical case scenario, for the past 40 years, more or less, because most of the commercial laws, by the way, they're 40 years plus. I came up with a new idea, and you will see it, by the way, in the commercial registry law. It's called the National Economic Registry. The short name is NER, سجل الاقتصادي. Okay, what does this mean? Let me resemble it in a very marketable way. So this record will be owned, this registry, the economic registry, will be owned by the Ministry of Economy, like Burj Khalifa, for example. The first story of this registry will be the commercial registry, which will be owned by every respective licensing authority. What are the other stories? Every single consolidated economic data, IP rights, commercial agencies. We connect with DFM, ADX, the tax authority, the Ministry of Industry. Long story short, we are creating a tycoon, more or less holding the big data. Okay, this is the National Economic Registry. Okay, the first story only in this consolidated economic data is the commercial registry, the commercial license. Okay, so the commercial license will be holding two references. The first reference, it's left to every respective licensing authority. They could put whatever reference they would like to. However, there is a binding reference that should be in every respective commercial license. And this reference, it will only be introduced, generated by the National Economic Registry. Okay, it's a long journey. It's not easy. Bearing in mind that some licensing authorities, they have not really migrated into the proper ecosystem for digital transformation.
Many, actually. Many.
It's a long journey. This is basically the objective, upon which, when we had this charming interactions with several licensing authorities, they have their own reasons to only share limited information. So let's tell you what, Uh, the immigration authority here, they hold a record for every respective person getting into UAE, whether local or expatriate, resident or visitor, correct? How about we do the same? And this is how we came up with the NER, the National Economic Registry. It's a long journey, but this is the objective.
Actually, a suggestion, and it's already made in our home country, that they have the national number.
Fadi, you know, now UAE is a federal state. Okay, we have 42.
My concern to link it with
42 licensing
Yeah.
authority. We have over, actually more than 42 licensing authority.
More.
Try to invite them for lunch. Then we will talk about legislation.
My question is a practical one. Sounds amazing, and it is a journey, but will it be open and accessible to the public?
It's already open.
This was my question.
Yes.
It is already open, by the way.
Because,
No.
and I'll tell you why. Because as a litigator, one of the issues that we find is access to information.
Yes.
So,
Of
course.
so I come from a common law jurisdiction. Let's say in England, you have the Companies House, you have the land registry. You can conduct searches. You can find out about assets, company information, directors' information. Exactly.
Unlike here.
Unlike here.
Very
And in
confident.
order to access information, what we have to do is go to onshore, open an execution case or whatever case, and then try and get hold of that information. So it becomes quite difficult, not agile, inflexible. And so my question is, and please say yes, make this open to the public.
Okay. Just before we start the event, we were discussing the data law, the data protection law,
Yeah.
correct? As well, that had been introduced in this particular legislation. Even, and please skim through this law, it's very abstract, by the way. This law, give and take, is like 30, 32 articles. It took us like almost a year and a half to come up with this law. Then the only winning element, rather than aborting the whole law, was to coming up with the National Economic Registry.
Yeah.
Even the governmental entities, they don't have open access to information. Just to protect, to extend safeguard to personal data. They have to justify and to identify what. So it's not an open. However, for the open data, it is available. Nowadays, we are talking with different private sectors regarding their interoperability to the National Economic Registry. Definitely, if we want to build it as day one, plan two to be, definitely we have to strike alignments with a private sector.
I mean, one of the attractions, I suppose, of Dubai is the fact that this data isn't that open, and I suppose it's sort of bridging that delta really between those various competing objectives. But interesting to know. Do we have any other questions?
On the DIFC, so we mentioned that if a company is established in DIFC or UGM, it will automatically have the UAE identity. So does this mean nationality? Yes. So does this mean that they can freely do business onshore? Like they can act as a
Did you hear the question at the back there? So just to summarize, the question was for companies that are incorporated in the free zones, ADGM,
Say yes, otherwise
DIFC,
I'll be saying
and
I'll be disagreeing with
retain the local nationality. Sorry, what was the rest of the question?
Can they operate onshore?
Yes, can they operate onshore? Thank you.
One more question that is relevant to banks, basically, because now we have restrictions to accept deposits from onshore entities to the banks established in the IFC. So if they have the nationality, does this mean that we can accept deposits or that we will not be able to accept deposits as well?
Okay.
Thank you.
So acceptance of deposits.
And park aside the banking issue. It's basically related to the central bank requirements. It's a total dilemma. Operating from or extending the geographical jurisdiction for those incorporated in free zones, free financial zones. There was an explicit article direct to the point. Can they do that or not? If as long the licensing authority in the free zone, the free financial zone allows that, it is doable subject to this company, not a branch. Again, they open a branch in a DGM or the IFC. It's a branch, it's not a company. There will be no chance to open a branch to a branch onshore. Okay? Branch to branch, the onshore licensing authorities will not approve that. What you can do is you can open a branch to a company incorporated in the IFC, ADGM, Media City, and so forth. Me and Fadi, me and Samer, me and Amira, we go incorporate a company offshore. This is a UAE company. Services, trading, selling items, manufacturing, and so forth. Okay? It's a UAE company. Can they operate onshore? Yes. However, they have to take the form of either a branch office or a regional office. This is an explicit article in the updates. Hello?
Yes.
Thank you.
No, I agree. But again, to Hassan's point, it depends on whether you're a regulated entity or not regulated. You mentioned bank. There are different regulations that you need to take into account. Law firms, there are different regulations that you need to bear in mind.
And just to add to that debate, I mean, from my experience, when you do have a bank that's incorporated onshore, they open a branch in, let's say, the DIFC or DGM. For the purposes of suing them, you can do so because it has the characteristics of the onshore company. Just to add that into the mix. We are done on time, so that's a perfect ending. Once again, can I just say thank you so much to panel members, to all of you for providing such an engaging discussion. Thank you very much. Thank you, everyone, and have a very good day. Thank you.